Former head teacher Neil Foden got 17 years for his child sex abuse offences. Rebecca Joynes, though, a former maths teacher, only got 6.5 years for hers. Why two such different sentences? Joynes was convicted of 6 counts of child sex abuse offences relating to 2 individuals. Foden, in contrast, was convicted of all of 19 counts of child sex abuse relating to 4 individuals. Joynes, 30 years old, was sentenced on the 4th of July 2024, 3 days after Foden, aged 66, got his sentence. Joynes is set to do only half of her sentence in prison. The other half she's due to do out on licence. Moreover, she will get a reduction to her sentence to reflect the time that she's already spent in custody. Foden himself, meanwhile, could be released as early as January 2035 after doing 10.5 of his 17 years. Foden's and Joynes' respective arrests give rise to some interesting questions relating to PACE, the Police and Criminal Evidence Act. Foden was arrested at work by plainclothes officers.
Mr. Foden, unfortunately I need to arrest you on suspicion of sexual touching of a child and sexual communications with a child.
Right.
You do not have to say anything, but it may harm your defence if you do not mention when questioned something which you later align in court. Okay. Anything you do say may be given in evidence.
That caution about the consequences of a criminal suspect's failure to mention to the police something that he or she may later rely on at trial is all important. Without it, a criminal defendant may have recourse to redress of some kind against the police in the event of a criminal trial. Given this, the plainclothes appearance of the arresting officers, which was, I think, intended to make the arrest a low-profile process so as not to excite the pupils, is nothing to make a fuss about, I'd say. Police don't dress in plain clothes in most cases of arrest, but then most arrests don't take place in a secondary school attended by over 1,400 pupils. To trigger Joynes' arrest, Joynes was given a friendly knock at the door of her home.
Hello, you okay?
Hi, we're looking for Rebecca.
Yeah, it's me.
Yeah, we're just coming for a second. I'm not sure how much you know what's going on, but my colleague's just got something that
So obviously, given what's happened, I know you've been sent home from school today, so you are under arrest at the moment on suspicion of sexual activity with a child. You do not have to say anything, but it may hang you.
37-year-old Gavin Plum, who was, on the 4th of July 2024, the same date as Joynes' sentencing, convicted of plotting to kidnap, rape and murder the TV presenter Holly Willoughby, didn't get quite such a friendly introduction to the police officers who, in October 2023, arrested him at his home.
Police! Stay where you are! Do not touch anything! Who else is home? What's going on? What the hell is going on?
Listen to what our colleague's got to say. Right, you're under arrest on suspicion of conspiracy to kidnap. You do not have to say anything.
What is going on? What are you talking about?
The following is the police's explanation for their method of entry into Plum's home.
Mate, if you'd have knocked, I would have opened and spoke to you.
As you said, the reason
I was literally just about to go to bed.
The reason that they're going into that is because of the offence that you've been arrested for. We need to make sure that we can gather as much evidence as we can as quickly as we can. So we've had to put the door in to secure the evidence.
Why, then, didn't they use this same method of entry to Joynes' home? Joynes gave 15-year-old boy A her number in a maths lesson, which facilitated their subsequent single out-of-school liaison. One liaison, I will stress, which included Joynes treating the boy to a shopping trip where she bought him a £345 designer belt and then taking him back to her flat and raping him, was all it took for Joynes to subject the boy to obscene sexual corruption. Earlier this year, Joynes gave birth to a baby girl whose father is boy B, the second of Joynes' victims. Joynes embarked on her illicit relationship with 15-year-old boy B, which was to last all of 18 months, while she was out on bail after being charged with offences relating to boy A. She obviously paid no attention to the bail condition of hers that said that she was, under no circumstances, to have any unsupervised contact with anyone under the age of 18. It would also seem that Joynes was still grieving the ending of her 9-year relationship with an adult male that came about when she was 28. This, you see, was her explanation for her revolting behaviour towards boy A and boy B. Boy B, for his part, understandably enough, takes no comfort whatsoever from this explanation. In his victim impact statement, which was read to the jury during the trial, he said, "I have replayed a lot of things in my head and spoken to a lot of people, and it has made me realise the full extent of the abuse carried out on me and the tactics that were used to do so. I was coerced, controlled, manipulated, sexually abused and mentally abused."
When he originally gave evidence, boy B was still in love with his former teacher. He said, "I struggled to come to terms with my abuse. I was in total denial. I felt as though I had betrayed someone I loved. I was coerced and controlled, manipulated and sexually abused."
Why someone with a job as a so-called superhead, which means that they're effectively head of not one, but 2 or more schools, and on a salary naturally that reflects that, would need to borrow £900 from someone for home improvements is beyond me personally. But yes, with a proven record of exam success at one school, School Friars in Gwinnett County, Foden was subsequently appointed executive head teacher or super head teacher of a nearby failing school in order to transform it. Holding a senior post in the biggest trade union for teachers and making frequent appearances on both local and national TV and radio over many, many years, Foden was a notably high-profile figure in the local community who was known, say some, for his charisma and for his gritty determination to keep his school a success. Now, getting child E, the first of his 4 victims, to lend him £900 to have his bathroom done up and then never repaying her was, arguably, the very least of his many offences against her. The two once had sex on the bonnet of his car, no less, during which he restrained her with his belt and called her his sex toy. The two had sex in other places as well, including, presumably, at the hotels where the two would stay when Foden was away at one conference or another. Foden would often take Child E with him to such events, you understand. Child A, meanwhile, whose period of abuse from Foden was substantially shorter than Child E's, and whose disclosures to the police led to Foden's arrest on the 6th of September 2023, reports that after driving her to some remote country lane, as he often did, Foden would make her consume vast amounts of water. Foden was looking to satisfy his urination fetish, you see, and after literally overfeeding his victim with water, he would press the lower part of her abdomen in order to apply a sufficient amount of pressure to her bladder to get her to pass urine. Don't let me mislead you though, from hugging Child A to kissing her to groping her intimately and to performing intercourse with her, Foden sexually abused her. Less than 24 hours after giving birth, Joynes had her baby daughter confiscated from her under a care order. Joynes has since been allowed 3 supervised visits a week from the baby, and boy B laments that his daughter returns from those visits smelling of its mother. That was a quotation. The question, though, is at what point, if any, will Joynes forfeit her PR, parental responsibility, for her daughter? Is she, in fact, already in the position of having no legal PR for her daughter? The law used to empower courts to remove a person's PR, whether for reasons of child sex offences or for other compelling reasons, when the court was satisfied that this was in the best interest of the child. However, this required the families and the former partners of perpetrators to instigate and fund proceedings to secure these orders to protect their children. Costs for those proceedings could run into tens of thousands of pounds. However, under a new rule that was introduced in May 2024, child rapists will automatically have their PR suspended. This means that the perpetrator will no longer have any say over key elements of a child's life, including whether they can access therapeutic support, go on holiday, or change schools. The case will then be referred to the family court, and it will be for the perpetrator to prove to a judge that it's in the child's best interest for their PR to be reinstated. Foden was controlling, callous and vastly arrogant. Due to both his success and his fame as an educator and leader, he clearly considered himself bulletproof. He was, above all, someone who was used to winning. In the witness doc, he told the court that, due to a medical condition, he was, in fact, unable to have sex. Equally, he was in no way fazed by either the screenshots of his explicit WhatsApp messages with his victims or the DNA belonging to him and to child E that was found on a pair of lace handcuffs that he had in his car, or the CCTV footage showing him getting his victims into his car and then driving off with them, or the descriptions from his victims themselves of his fondness for holding their hands, talking dirty to them, and of course raping them. It was all a stitch-up, you see. Foden was, in his own words, not guilty. When you plead guilty to a criminal charge, you don't get a trial, and you also get, in most cases, a reduction of the sentence that you would have got if you'd gone through to trial and been convicted. Keep in mind that Foden would have been presented with the evidence against him that I mentioned earlier before deciding on his plea. I can't help but think that Foden was counting on being cleared of not just a single charge against a fifth girl, which was actually the case, but of every last charge. Looks like things didn't quite go to plan for him.
A head teacher in North Wales has appeared in court accused of child sex abuse.
A head teacher from Old Colwyn accused of child sexual abuse is facing 21 charges.
The trial has begun of a head teacher accused of sexually abusing 5 children. Neil Foden from Old Colwyn in Conwy County denies 20 charges dating back to 2019.
Foden showed no remorse and was jailed for 17 years.
North Wales Police welcome today's sentence. It reflects the hideous nature of Neil Foden's offending.
Rape involves the penetration of the vagina, the anus or the mouth by a penis. This means that while a woman can certainly be an accessory to a rape, she can't actually commit a rape. She can't be a rapist. I am wrong, therefore, to say that Rebecca Joynes raped 2 teenage boys. There are sexual offences other than rape that a woman can commit, and Joynes has been convicted of 6 of those offences. But do Joynes' victims feel any less violated, corrupted and traumatised than Foden's victims?
I was coerced and controlled, manipulated and sexually abused. Now,
as far as criminal liability is concerned, should it truly matter whether the offender, person A, is performing or receiving the act of penetration? In the matter of sex between an adult and someone underage, there is at least one country where that is, at law, statutory rape, whether the perpetrator is a man or a woman. That is the law, as far as I'm aware, in at least some parts of the USA. I'm not necessarily saying that the USA should serve the UK as any sort of guide to lawmaking, of course. Understand, though, that in the UK, rape is one sexual offence that can attract a life sentence. Keeping that in mind, and keeping in mind also everything I've said about the potential trauma to someone who has been forced to have sex with another person, whether through physical violence or through emotional, psychological violence, shouldn't we in the UK update our definition of rape so that a woman can in fact be deemed at law to be a rapist, so that the sick, sexually depraved and morally depraved Rebecca Joynes of the world can get the life sentence that they deserve for their own sexual abuse of children. Strictly speaking, Neil Foden got a life sentence for his offences, since life can mean as little as 15 years and he got 17. However, as I mentioned earlier, he could be out in as little as 10.5 years. Both Foden and Joynes will be on the sex offenders register for life and will of course never be allowed to work with children again. If this video has gripped you, I recommend you to watch this one next. I'll meet you there.